So the first part of my talk is titled Common Good Constitutionalism. An important recent development in American constitutional law has been the rise of non-originalist jurisprudence by legal scholars who are either conservative or, to use a jargony word of the day, conservative adjacent. The most influential of these contemporary non-originalist forms of legal conservatism or movements close to conservatism is that articulated by Harvard law professor Adrian Vermeule in his so-called Common Good Constitutionalism. This approach has been expressed by Vermeule in many lectures, in his important 2020 essay in The Atlantic titled Beyond Originalism, and in his 2022 book titled simply Common Good Constitutionalism. Let me sketch a very short outline of Vermeule's methodology of constitutional interpretation. First, Vermeule maintains that the construction or interpretation of legal texts, including constitutions, when done through acts of government, must always be informed by the animating and fundamental purpose of that government. So he and I are not talking about interpreting the Constitution in any other way than by government itself. Not by law professors in lecture halls, not by law students absorbing those lectures, or by undergraduates in their dorm rooms. Following Aquinas, Vermeule holds that when government acts, it must always first act by asking the question, what is the purpose of governmental action in the first place? Therefore, a part of the act by government of interpreting the Constitution must be the act by these governmental agencies of asking precisely the question, what is the fundamental purpose of governance? Now, as a side note, this requirement that Vermeule outlines, the requirement placed on government agents when acting to interpret the Constitution to ask the question of purpose in government, is no requirement unique to judges. To be sure, the interpretation of the Constitution by courts is vitally important, since our federal and state courts are, of course, invested with the power of judicial review, the power to interpret and then apply as legally binding to others their interpretation of the Constitution. Now note, we can make a side point here to say not all countries have that. Some countries still retain the idea that their governmental courts, their courts as an organ of government, should only issue in advisory decisions, not in legally binding ones. But be that as it may, we should remember that the courts are not the only agents of government that interpret or should interpret the Constitution. Presidents have to do it when deciding to sign or veto a bill, and legislators must do so when proposing or voting on bills. For presidents and legislatures, after all, are officials sworn to uphold the Constitution, and you simply cannot uphold that which you know to be incompatible with what you are to uphold. Moreover, you cannot uphold that which you do not understand. So in reference to what Justice Jackson called the glittering generalities of the Constitution, those points where the text of the Constitution is sonorous but vague, in reference to these, legislators and presidents also have, in the exercise of their official duties, an obligation of constitutional interpretation. Now, having said this, very, very frequently, the most consequential acts by which government interprets the meaning of the Constitution are done by courts. And most consequentially of all, by highest courts, be it the state Supreme Courts or in terms of the U.S. Constitution in matters involving the U.S. Supreme Court. Let's focus on the U.S. Supreme Court. On Vermeule's common good constitutionalist approach, Supreme Court justices, in exercising judicial review, must first ask, what is the purpose of the United States government? Note, for Vermeule, following Aquinas, this question cannot be a deferrable one, as it is in originalism. Supreme Court justices, in this preliminary and foundational exercise of asking what is the purpose of the U.S. government, cannot defer to others and say their answer to this question is simply going to be what the understanding actually was of the individuals who wrote the Constitution. They must ask the question of governmental purpose simplicator. They themselves must ask and answer this most basic of questions. In the act of interpreting the Constitution, Supreme Court justices must be guided by this orienting question. In turn, to this very question, Vermeule answers, following again Aquinas and others, that the purpose of government is to advance the good, first, of the citizenry, and then of all the persons under its jurisdiction, or the common good. So, since it is in order to serve the good of citizens and of all also that government acts, and the most consequential judicial acts are the acts of judicial review, the binding interpretations of the Constitution, actions by which the Constitution is interpreted must be actions that serve the common good. But how do justices do their most consequential act, namely interpreting the Constitution? They, of course, can only do so if they have some means or method of constitutional interpretation. That's the way by which they act. They must use, therefore, some method or some methodology, as I said. The most common means or methods of constitutional interpretation fall into a set of relatively well-known approaches, often called schools of constitutional interpretation. What Vermeule's thought entails is that any method utilized by a justice to do his or her act of constitutional interpretation must be one which itself serves the good of citizens and of all persons. For Vermeule, the question thus becomes, for conservatives, do the prevalent modes of constitutional interpretation adhered to among conservatives serve, in fact, to advance the common good? Now, the modes of interpretation that have become predominant since the modern conservative ascendancy in the federal judiciary, starting at least with Reagan, then going through in 1982, the founding of the Federalist Society, all the way up through the presidency of Donald Trump, the predominant means and modes of interpreting the Constitution have fallen into those schools known as textualism and originalism, and an overarching sense of judicial restraint. Now, textualism is a mode of interpretation that instructs judges to be guided by the words in the law written in a constitution's text. Vermeule's question becomes, does this method serve the good of citizens? Now, the answer is in many cases an unqualified yes. Textualism is good for the citizens by the way it affirms their political importance, that is, by the way the people in their capacity to make constitutional law are affirmed, and their capacity to have a say in what their government will be is upheld. Textualism also serves the good of the citizenry by the way it protects them from elites blithely robbing them of this dignity, or even seizing power to more concretely harm their good. Textualism also serves the good of the people by according government greater legitimacy, which itself ultimately resounds to the good of the citizenry, since people are better off, all things being equal, in a government that they see as legitimate than in one that they do not. Another prevalent mode, originalism. Originalism in its now common iteration is known as the originalism of prevailing public meaning. And it is at root an extension of textualism. It holds that where the legal text is unclear, Judges must repair to the people's will as discerned by what the people most likely meant by the words they let be enshrined in their Constitution, which is a datum best demonstrated by the prevailing meaning of the terms at the time the text was adopted. Since originalism is at root an extension of textualism, it advances the good of citizens in a similar way, namely by affirming the people's political importance in forming their government, by upholding their capacity to have a say in the structure of the government under which they live, by controlling the elites, by reining in abuse of power, and by advancing legitimacy. However, if we take to heart the idea at the very core of common good constitutionalism, that government in all its actions must be acting to advance the common good, we have to ask anew. We have to ask in a more penetrating manner. The question, is textualism and is originalism good for citizens and for all persons? And common good constitutionalism answers, not always. And shame on the conservative household for too lazily assuming that they always do. Judging the good to citizens of textualism and originalism must become a more nuanced examination. Yes, the good that accrues to citizens from judges deploying textualism and originalism is substantial, but is not eo ipso or by automatic operation always dispositive. For importantly, textualism and originalism are in effect species of legal positivism. What is there before the judge, what has been placed or posited in the documents they are to interpret and apply in individual cases, those are controlling independently of considerations of the people's genuine, flourishing, or true good. However, we are now experiencing, Vermeulen emphasizes, a time when substantive ungoodness is being enshrined in positive constitutional law at the state level, with state constitutional amendments positing in the state's highest law such ungood or even evil provisions as abortion up to and even after birth, gender mutilation, drug use, and other examples. Moreover, the forces operating at the state level which have effectuated these changes lust after national power, and should they achieve it, have threatened to embed these and other evils in federal constitutional law. So how does common good constitutionalism deal with this noxious trend? There still remain genuine goods that accrue to citizens by having judges defer to the popular will. But this genuine good must be balanced against the substantive harm to the public good such amendments would produce. The graver the ungoodness, the more the good of textualism gets outweighed. So by means of such balancing, if a constitutional amendment were manifestly and irredeemably unjust, it could be overridden for the sake of the common good. If less unjust, the good of textualism or originalism could outweigh such acts of judicial rescission. However, another important point needs to be borne in mind. The legal left in many states does not have a vast supermajority. Political opposition to it remains. And so in many instances at the state level, the constitutional amendments that have been enacted under impetus of the legal left are stated in the constitutional text somewhat vaguely, since only vague or what from the left perspective are watered down provisions can get enacted in the first place. And the same trend of watering down would likely prove true in any federal amendments being pushed by the radical and rising legal left. So at the federal level and in state constitutional law in many swing states, the substantive malevolence of amendments will, in the text, likely be watered down, And this will often take the form of constitutional text being quite vague. In these cases, textualism will not give a univocal answer. Moreover, because the texts themselves are vague. Moreover, in these cases, the originating history and prevailing public meaning of the provisions in the text will have to be such that they record opposition to the malevolent designs of those proposing them. And so originalism, too, will not give rise to a univocal answer, since there will not be a univocal public meaning of the vague terms. So in these cases, which are likely to be common at the federal level and are currently common in some swing states, what is Vermeule's common good constitutionalism to do? There is little place for a straightforward balancing of a clear text that is unserving of the public good against the good of textualism and originalism, since the text and original public meaning are vague or conflictual. So what do we do? Common good constitutionalism, it seems, from Vermeule's writings, counsels in these situations the following approach. A judge should be chastened in interpreting state or federal constitutional law, should be chastened to follow a strand of thought developed by a broad part of the populace, expressing what these constitutional provisions mean and are intended to do. This chastening will restrain judges from assuming the status of purely Platonic guardians who can act without concern for the public's originating thoughts on the meaning of their constitution. To this extent, the judge upholds the genuine good of originalism. However, the judge should choose to apply that strand of broadly held views about the meaning and purpose of a vague provision that is in fact best suited to advance the general and genuine good of citizens. In other words, the judge should optimize over historically available strands of ideas about what the provision was meant to do and mean, applying that strand best suited for the people's genuine good. This is how the good of citizens, this is how the good for citizens of originalism and the good to citizens of avoiding harmful laws are balanced in cases where the text and history are ambiguous and conflictual. All right, so that's a kind of a summary of common good constitutionalism. Second section is titled Kirkian jurisprudence. Here, I submit, is just where the idea of a Kirkian jurisprudence comes to the fore. For Kirk's methodology in the roots of American order strikes me as doing something very similar. His work, I believe, selects for emphasis and preservation what he takes to be the best elements that inform the emergence of the American constitutional order. His is not a purely originalist argument in the positivistic sense of saying, these trends that I survey did alone shape the American order, and because of this brute historical fact, are to be credited and preserved. No, he's doing something more subtle. He is arguing that of all the actual influences on the emergence of the American order, the ones he emphasizes are the morally most salutary. So that's my reading of Kirk. The influences he does emphasize of Jerusalem, Athens, Rome, London, and their associated ideas are, in fact, historical trends that did influence the formation of the American constitutional order. It's just that they're not the only ones. They are emphasized and elevated because they are the morally best inputs on America's constitutional order. Now, this constitutes a clear parallel with what a common good constitutionalist must in many cases do, namely optimize over, choose the best of the broadly held positions that help to shape a constitutional amendment when it's unclear. Again, in Kirk's analysis, I think there's a clear parallel here because he looks to originating and informing traditions that did in fact feed the American order. He does not simply philosophize directly about what his own personal arguments are about which regime type is best, and then say that that regime type should be preserved. This isn't just a straightforward exercise in his own philosophy about the nature of a legitimate or a just government. But nor is it an account that defers entirely to the historical record, surveying and thereby having established that they in fact influence the American order, defer to all of those inputs. He selects among the inputs. He is disciplined by history, by what actually did contribute to the shaping of the American order, but he is no slave to history. He selects among the traditions that informed and shaped the American order, those traditions that did so to the genuine benefit of American citizens. Now, I think a moment's reflection can justify this reading of Kirk's methodology in the roots of American order. For there are no doubt traditions that could well be included in, for example, Chapter 9, which examines the formation of the constitutional text. There are no doubt traditions which could have been included in that chapter because they did, as a sheer matter of history, inform the creation of the Constitution and of American order. But they're not. We can think specifically of the arguments of South Carolina's delegates to the Constitutional Convention and the influence they had on North Carolina, Georgia, and even to some extent Virginia. The South Carolina delegate Charles Cotesworth Pinckney, for example, was a strong apologist for the slaveocracy. He opposed attempts, for example, to end the importation of slaves, arguing that South Carolina's economy required the continual infusion of new slaves. And he came to support the constitutional provision authorizing an 1808 ban on the importation of slaves only by compensating himself with the thought that it would thereby make his slaves more profitable. Indeed, some sources record him boasting that he supported the U.S. Constitution because through it, according to one account, quote, "we have obtained a right to recover our slaves in whatever part of America they may take refuge, which is a right we had not before." And Pinckney was no lone wolf. He represented an intellectual tradition of slave owning and slavery justification that went back for decades in the Carolina Lowcountry and elsewhere. A point the magisterial work, The Mind of the Master Class by the Genoveses, makes plain. His was a tradition of thought that did in fact shape the American order, but it is one that Kirk leaves almost entirely unmentioned, because it's not a salutary contribution. For these reasons, I believe we can speak of a Kirkian methodology and we can associate it with the common good constitutionalism of Vermeule, and so in turn speak of a kind of Kirkian jurisprudence. All right, so those are 2 points in the argument. Now I want to take the liberty of just moving us into a set of discussions about contemporary issues and ways in which contemporary issues might be informed by a Kirkian approach. If we assume that this selective adoption of traditions is a valuable approach, how might we apply it to a contested contemporary issue in constitutional construction? Let me briefly assess, throw open for conversation, of course, the issue of whether the Constitution requires that individuals be recognized as having the broad right to bear arms in personal self-defense. So broad right with, I'm not saying none, but with a relatively small amount of restrictions for the purpose of personal self-defense. It was only in 2008, in the Supreme Court case of District of Columbia versus Heller, that the Supreme Court said that the Constitution's Second Amendment was a personal right and that it was not therefore indexed to service in any militia. It was only 2 years later, in the Supreme Court case of McDonald versus City of Chicago, 2010, that the Second Amendment with this personal interpretation unindexed to service in a militia was incorporated against the states via the 14th Amendment's due process of law clause. And I think the students here know about how that process of incorporation works. The idea is, and this is Scalia's interpretation, Justice Scalia's, the late Justice Scalia's interpretation of how substantive due process works. So the due process of law clause, of course, which is also found in the Bill of Rights, the due process of law clause says, right, that there can be no laws, right, that violate, your right to life, liberty, and property without due process of law. It doesn't say there can't be any laws that take away your property. I wish, because then I wouldn't have to write checks on April 15th. It doesn't say that the government can't take away your life. Yeah, the death penalty was common at that time, right? Of course there are laws which can take away your liberty. We have prisons after all. So it's just that those laws which take away your life, liberty, or property can only be laws consecrated with the name law if they come through an appropriate or due process of lawmaking. And so we have the idea of procedural due process, that there are some procedure during the course of either a trial or during the course of lawmaking itself that have to be there in order to say that that process that would result in the denial of your liberty or even the death penalty or taking my taxes or confiscating your property for public uses, that process must itself embed certain practices which are fundamentally fair. That's known as procedural due process. And then substantive due process, again, I think this is just a summary, a helpful, I hope, reminder for you. I'm not saying I'm teaching anything new, but substantive due process takes the form of saying that, well, there are certain deeply rooted principles that we are unable to consecrate with the elevated term law because any process of law which resulted in their violation could not be a due process of law. No due or appropriate process of law would result in an egregious outcome. So that's the structure of substantive due process and incorporation of the 14th Amendment. The process of incorporating the Bill of Rights through the 14th Amendment is just simply an exercise in substantive due process, because in asking yourself the question, what are those basic principles that no process of law, however fair it might at first appear to be, cannot really be considered fair if it resulted in the violation of those rights or those principles? What are those things that no process of law can violate and be considered a due process of law? Incorporation says it's the provisions of the Bill of Rights. Now, again, you may also know that in American constitutional law, we have a debate that takes place around a little bit after a little bit before, a little bit after the Second World War, about whether there's going to be total incorporation, so those things that no process of law can violate and be considered a due process of law are going to be all the provisions of the Bill of Rights, or are they going to be selective incorporation of the provisions of the Bill of Rights? And then also the question, are there other elements of what we consider to be so fundamentally right, true, and just that we can't have any process that violates those be considered due? Can that storehouse include elements not found in the Bill of Rights? And ultimately what's hashed out in contemporary Supreme Court case law is the idea of what's known as selective incorporation plus. You take almost all, there's certainly a few elements of the Bill of Rights, indictment requirements, a few others that have not been rendered applicable to the states via the 14th Amendment's due process of law clause. But so there's still a selective element. You don't take all of it and apply it to the states. But you don't limit yourself just to those things which are found in the Bill of Rights, because there can be also some fundamental liberties that may not find expression in the text of the Constitution, but which are so fundamental and deeply rooted that they have to be upheld for a process of law to be considered due. If it violates them, that process by which they were violated cannot be a due process. Any examples here that come to your mind of rights which are held by the Supreme Court to be so fundamental that no process of law can be considered due, which overrides them, but which are not specifically found in the text of the Constitution? Someone besides a, brilliant, yes, sir, young man. Absolutely. So you think about parental rights, right? So you think about the idea of teaching your children a foreign language in Meyer versus Nebraska. You think also about, although this isn't really the thrust of the case, Pierce versus Society of Sisters is often focused on, and definitely the idea of parental direction of the education of one's children is found in that case, but that case primarily is focused on the right of the association of the nuns to run a school the way they want. All right, but it does have implied that idea of parental control. So certain ideas of parental control, and then, fast forward, you're going to get also some interpretations of this bank or storehouse of basic rights that maybe we would venture to say most in this room wouldn't agree with. Like, what would be a contemporary example of that? Yes, sir.
Privacy.
Well, the right to privacy found, of course, in the 65 case, right, of Griswold versus Connecticut, and then the further elaboration upon that in terms of both privacy, but then also being able to define the mystery of existence as well. Where does that come from? Anyone?
Fair.
What? Well, that's right. Planned Parenthood versus Casey, so a right to abortion, and then also a right to gay marriage. All right, so Kennedy will invoke these ideas about the nature of marriage being such that it has to include the ability for couples of the same sex to enter into it. So substantive due process is a very tricky thing, right? Because the question becomes, how do you define that storehouse of basic ideas that the people are unable to overturn, because to do so, the process by which they overturn them cannot be considered a due process. Okay, well, that's a constitutional law aside. It's relevant to our conversation, but it is to some degree an aside, because what I want to focus on at this point is that for 15, 20 years now, we've had the incorporation of the Second Amendment under the idea of the due process of law clause of the 14th Amendment. You've had it incorporated against the states. But the incorporation of the Second Amendment has not incorporated a clear understanding of the extent to which the right of personal gun ownership can be regulated. It was not incorporated under the understanding that that right of personal self-ownership of firearms would be absolutely free of any potential restriction. And the Supreme Court's had to wrestle with the question of what are the constitutionally permissible restrictions that can be imposed on the right of personal firearm ownership. And we get to that question explored by the Supreme Court in 2022 in the case New York State Rifle and Pistol Association versus, can anyone fill in the blank? Bruen. All right, absolutely, Bruen. So in that 2022 case, the court held that restrictions on gun ownership are constitutional to the degree that they are not considerably out of line with the historic practices of states in regulating firearms. Well, it is just here in Bruen that I think the common good constitutionalist and Kirkian approach becomes especially serviceable. For there are a wide range of traditions about guns and the regulation in the history of the United States. So how are judges to apply the holding in Bruin, which says regulations must not exceed the traditions of gun ownership, when there are multiple traditions on gun regulations? A Kirkian jurisprudence would endorse judges not applying straight away their own ideas as a pure matter of philosophy, but rather optimizing over historical traditions. So looking at the array of traditions about gun regulations, which is disclosed across American history, and picking and applying that tradition which they see as best serving the common good.
Squire.
Now, I want to go even further. And I want us to briefly think about whether there are any traditions about gun ownership and the regulation thereof which are more morally salutary than others. Well, in just a terse examination of this issue, I want to point your attention to a tradition that I think should be emphasized because it's a tradition that I think does subserve the public good. It's a tradition that held that the right of gun ownership in self-defense should be broadly construed, so limitations should meet a high level of justification on it. Why? Because a broad right of gun ownership and self-defense improves the moral virtue of individuals. This tradition of thought holds that gun ownership for the purpose of self-defense should be broad, in considerable part for the purpose of maintaining personal virtue. This tradition expressed the idea that not being able to defend oneself and thus relying on the government or on the community to do so breeds immoral traits and dispositions. For if you are in need of the protection of others, you are likely to become morally weakened by the way that you become inclined, for example, to violate the Decalogue, to lie, to tell the powerful in government and the leaders in community what you think they want to hear, whether you believe it or not, simply to ensure that they will protect you. You can also become indifferent to the true good of others, since you may well have to express support for views that you may strongly believe genuinely hurt others, but you have to give your support to it simply to muster and maintain the support of your protectors. But lying and being indifferent to the good of others is immorality. Dependency is morally disempowering, this tradition says. On top of this rests fear. As Dr. Jones remarked so eloquently yesterday, fear itself often breeds immorality. The inability to legally arm oneself in defense can breed in turn vice born of fear. Last of all, failure to defend oneself by arms, if necessary, can cause one to violate the will of the Creator by submitting oneself needlessly to the prospect of serious attack or harm, committing thereby something dangerously close to the sin of suicide. In all, fear and dependency breed immorality and therefore threaten the moral vocation of humankind, the vocation to live life morally. Well, let me give you a few expressions of this tradition about gun possession. The American historian David Koppel, in an important essay, The Religious Roots of the American Revolution and the Right to Keep and Bear Arms, documents how many ministers throughout the 18th century were very conspicuous in their ownership of firearms, and that they preached just as they acted. Reverend Simeon Howard, for example, preaching to Boston's Militia Artillery Company in 1773, thundered that without a commitment to bear arms comes a spirit of submission, he said, and that this submissive spirit creates an environment conducive to sin. He says, quote, "A spirit of submission tends toward slavery. and complete slavery implies every evil that the malice of man and the devil can inflict. And it here means not just the evil that the dominator, the slaver, can impose upon the dominator or the enslaved, but the evil that the enslaved will do to mitigate his position. The groveling, the dissimulation, the constant rivalry among others for the eye of the protecting master. Reverend Samuel Cooper in 1780, in his sermon on the day of the commencement of the Constitution, states even more explicitly this connection between a failure to bear arms in defense of oneself, and dependency and servility, and the connection between dependence, servility, and moral degradation. When he preaches that the spirit of servility is commonly accompanied with the meanest vices, such as adulation, deceit, falsehood, treachery, cruelty, and the basest methods of supporting and procuring the favor of the power upon which one depends. Close quote. This tradition holds that the possession of arms for self-defense is a key to maintaining morality, and thus regulation should be loose, not non-existent, but not overly tight on the ownership of guns. And this is a tradition that did, in fact, inform a tremendous amount of state regulations over time with respect to firearms. It's a tradition of gun regulations. As the court in Bruin says, a regulation of firearms cannot be wildly inconsistent with, must be, therefore, consistent with. And further, this tradition, I argue, should be emphasized because it is one that works to the true good of citizens. This tradition that advances, this tradition that sees the common good being advanced by a right of firearm possession and self-defense, serves the common good by the way, in a number of ways, but one way that I want to emphasize is precisely by the way it can underscore the morally problematic character of dependency. That dependency on government and on others inflicts no moral harm is an increasingly attractive and seductive view among many. The idea that experiencing dependency is morally unproblematic is what I think is harmful to the common good. Now, in one sense, we can say that operatives, perhaps of the Democratic Party, they explicitly or implicitly recognize that dependency on government programs makes good Democratic voters, and they quite often genuinely believe that both the policies that they're able to enact by the votes of those who are dependent upon them and are genuinely helpful to the common good, and that there's therefore no moral harm in dependency. It actually works to their advantage. So we see a little bit on just raw political strategies. But I think we also see this idea of the morally unproblematic character of dependency in the thought of those of a more intellectual stripe. Think about it this way. One way to become dependent is to be a victim of a person or a set of persons or a set of social forces which have made one dependent. And here we have to note the high estimation of victimhood, its elevated status in the minds of far too many intellectuals. Think of this common claim among intellectuals on the left. Quote, unlike those who are privileged, oppressed subjects have the epistemic advantage of needing to understand the oppressor's perspective for various reasons. For example, to avoid the negative consequences of the power of the privileged by finding more efficient ways to serve them. Having to serve them, being victimized, being in a condition of dependency, is in a real sense an advantage. It lends to one experience that confers greater insight and authority. Many feminists and intersectional advocates argue that the oppressed must be deferred to because they know more by dint of their oppression than do others. there's certainly a sense in the intellectual discourse today that there's something morally unproblematic to a substantial degree in being in the condition of dependency, as victimhood is one expression of dependency, dependent upon those who have victimized you. Now, the originating articulation of this idea in American thought, I believe, can be found in some of the short passages in the famous book by W.E.B. Du Bois, The Souls of Black Folks. Many of you may have read this passage. He writes about double consciousness. He writes, quote, "It is a peculiar sensation, this double consciousness, this sense of always looking at oneself through the eyes of others as well as through one's own eyes." Yet Du Bois continues, "This sensation is not only peculiar, it is in a way elevating. For, quote, the Negro blood has a message for the world," unquote. A message which he implies is especially insightful precisely because of the experiences accumulated through double consciousness. Seizing on this kernel of thought, later feminist and post-colonial thinkers have constructed an entire edifice of epistemic superiority conferred by the force of victimhood. And then on top of all of this somewhat abstract epistemology, we can just think of the real-world condition of receiving more stuff if you can present yourself to the progressive elites as a victim. For these reasons, many reach the following syllogism. Victimhood is beneficial. Victimhood is a species of dependency. Therefore, dependency is not unbeneficial. But this syllogism, I maintain, is ill-conducive to the genuine good of our fellow citizens. In turn, one way we can advance the public good is by affirming a broad right to bear arms in self-defense, precisely because this right frees us from the vice grip of dependent-mindedness. It says it is not good for you to rely on the state for your protection. It says that such a dependence is a pathway to the servile mind, a road to a corruption of spirit that would see independency a matter of no moral concern. In a manner of speaking, this tradition, affirming the right to bear arms in self-defense with minimal state regulations, views personal weapons as a sign of anti-victimhood, as a token of non-dependency. And affirming this semiotics of the Second Amendment would represent a noble exercise in what I've called Kirkian jurisprudence. So I hope with those thoughts I have stimulated your thoughts on this matter and provoked you to ask some questions, because there's a lot of things that we can do to hash out this argument and talk more about it. Thank you very, very much.
Thanks for watching this video. I hope you enjoyed it. Please remember to like, subscribe, and share, and feel free to check out one of the recommended videos.